Good day. My name is Eric Masura. I'm the managing attorney at the Kingsborough New American Center. And this is a video regarding Liberian Refugee Immigration Fairness Law. This is a series of videos that Kingsborough Community College, Single Stop, and New American Center will be presenting to help our students and Kingsborough family get more information about things that they may benefit from. The Liberian Refugee Immigration Fairness Law is a new law that came about in December of 2019 that allows Liberian nationals to apply for their green card, provided that they have been in the United States since November 20th, 2014. We're going to present a general overview so those who might be eligible can capitalize on this opportunity. The requirements of the law are that the person applying must be a national of Liberia or the spouse, unmarried child under 21, or unmarried son or daughter over 21 of that Liberian national. The distinction is a purely legal one, an unmarried child generally for most people. They have to have been continuously residing and physically present in the United States from November 20th, 2014 to the date they properly filed the Form I-485 application for a green card. They also must not have been convicted of any aggravated felony or convicted of 2 or more crimes involving moral turpitude. And additionally, they must not have ordered, incited, assisted, or otherwise participated in the persecution of any person on account of race, religion, nationality, membership in a particular social group, or political opinion. It's called the persecutor's bar. And the application must be received by USCIS by December 20th, 2020. Some important things to note about the LRIF, Liberian Refugee Immigration Fairness Law, is that an individual can apply even if they were ordered deported previously and are still in the United States. The applicant may apply even if they overstayed their visa. So if they entered in on a visitor visa and overstayed their time, they're still eligible to apply. An applicant may apply even if they crossed the border illegally, entered without inspection. An applicant does not require labor certification, and the applicant is not subject to the new public charge interpretation of adjustment of status. So if they had taken public benefits in the past, this does not prevent them from applying for this green card application now. And the application is fee waiver eligible. So if someone is on economic hard times, they can apply for a fee waiver so that they do not have to pay the application fees to USCIS if USCIS deems their evidence sufficient to sustain such a waiver. Now, if you are interested in applying or may know someone who is, they can contact us at the Kingsborough New American Center. We're located at 2001 Oriental Boulevard, Suite T8, 108C. Our phone number is 718-368-5600. Our email addresses are listed on the screen. So I'd like to get the main points out of the way for those eligible who are eager to apply. I will go into now the other elements of this law for people's own edification. The law comes about as a provision, part of the National Defense Authorization Act for fiscal year 2020. And for our purposes, the main meat and potatoes of this law is uninteresting to us. We're looking here at other matters. And our section starts all the way at 1112 of a 1,119-page act. So here, subtitle B, Other Matters, section 7611, Liberian Refugee Immigration Fairness, explains the scope of the law and how one applies. Now, the law is fairly straightforward and simple. Here on page 13, Part C1A, it only requires that the person is a national of Liberia and has been continuously present in the United States during the period beginning on November 20th, 2014, and ending on the date when they submit the application. Part B expands that criteria to those who are a spouse or child or unmarried son or daughter of the person described in A, the national of Liberia. Fairly straightforward. In early April, USCIS, the agency tasked with handling these types of cases, sent out a policy alert clarifying their stance on the law, interpreting as they tend to do, on how they're going to process these applications. So they issued new guidance on the Form I-485 and updated their policy manual on how they're going to adjudicate these applications. The instructions for the I-485 listed I-485 LRIF on uscis.gov. It indicates what documents they want with the application so they can properly adjudicate it under this law. More importantly, USCIS updated the policy manual, which shows how they interpret the law and how they're going to adjudicate these applications. Specifically, we're interested in eligibility of family members. So here, USCIS, in its discretion, has determined that they will adjudicate the applications of family members only once the principal Liberian national has applied, or concurrently when the Liberian national applies. Meaning, if you're the spouse of a Liberian national who's been here since November 20th, 2014, you cannot apply before that Liberian national applies for their own application. This is a discretionary measure. This is the policy, not the law. This is how they're going to interpret and adjudicate these applications. Important to note the difference between the law and the policy, as there might be some mechanisms in which to bend the policy in your favor. I can see a situation where a lawsuit might end up to stick to the law as opposed to the policy. But generally speaking, for smooth sailing, it's best to have the Liberian national apply first, followed by the spouse or children of that Liberian national who might also seek the benefit. That being said, if you require any more information on the subject or would like to discuss your ability to apply for the Liberian Refugee Immigration Fairness Law, please contact us at 718-368-5600 or email us at the emails listed on the screen. We'll be gladly able to give you a consultation to see if you are eligible under the law. Thank you and good day.